These are some excerpts from a meeting we had with Seattle City Council member Tammy Morales in spring of 2021.
I've been a landlord-tenant attorney for probably about 11 to 12 years. I did start out on the tenant side with the Housing Justice Project. And I had also worked through the Seattle Department of Construction and Inspections over at the Property Owner and Tenant Assistance Units. I've had 3 clients murdered over the past year. I have had numerous stabbed. I have had countless assaulted at the property. 99.9% of tenants are absolutely wonderful and absolutely great. There is a 0.1% that terrorize the other tenants. And that's really what we're concerned about.
We had a female resident who moved into a 1-bedroom apartment on Capitol Hill. Her next door neighbor would block the egress and the entrance and exit of the female resident every time she'd come out of her unit. Just to get downstairs when she'd come home, would make sexual advances to her, and ultimately threatened her safety, living as a single woman alone. The police were called, and ultimately the female resident, for her own safety, decided she needed to break the lease 6 or 7 months early in her year lease. We understood why. We didn't have any, talking to an attorney, didn't have any legal ground to get rid of this individual, according to what we were told.
I understand that a lot of people think, well, Just Cause has provisions for criminal behavior. It should have a provision for this, or they think it already exists. So if Ryan could explain to us, well, what exactly is the real way that this plays out in the real world?
Sure.
When somebody tries to evict because of harassment, what happens? Why doesn't it work?
This is the crux of my question too. I think I'm missing something here in why, if there's so few people you would want to evict anyway, and we have a list of legitimate reasons why you would be able to kick them out. Where's the disconnect there?
Oh, absolutely. So the disconnect there is that in an issue of harassment, it would be a 10-day comply or vacate notice. Now, under Seattle law, as you're aware, it's 3 10-day comply or vacate notices before you can actually move forward with a 20-day.
Maybe you should just walk through, because maybe not everyone is aware of how that works.
Under the current Seattle law, in order to issue a 20-day notice to terminate the tenancy for bad call or for behavioral issues, you need to have 3 or more 10-day comply or vacate notices in a 12-month period.
And that means comply with rules in the lease, right?
Comply with the rules in the lease.
So they have to have broken a rule in the lease, and you have to serve them with a notice, 10-day or comply or vacate, when they break a rule in the lease. Now, if they just say they're going to stop, and they stop, then that's the end of it, right?
Yeah. So if there's an issue like harassment, harassing of another neighbor, harassing of management, this would require a 10-day comply or vacate notice, because in order to issue a more stringent notice, we would need an arrest that would be associated with this. So let's say we have one tenant harassing another tenant. This gets brought to the attention of management. Management issues a 10-day comply or vacate notice. If the tenant holds off for 60 days, that notice becomes void and becomes stale, and management have to issue another notice. Now, let's say they hold off for another 60 days, then the behavior resumes. We get to that 3rd notice. Now, at that 3rd notice, now we can issue a 20-day notice to terminate the tenancy. But when we go to court, what we have to do is go ahead and prove, prove that each and every single allegation that previously occurred did actually occur. Even if we have a restraining order from a court stating that they occurred, we still have to go ahead and go to court and prove this issue. Now, I think Charlotte has brought up an interesting idea that states if a tenant is granted a restraining order, that may be a just cause, or a tenant or a staff member is granted a restraining order, that should be maybe another one of the reasons for just cause, because while they might be able to get away with it by just complying with that notice, the issuance of the requirements for the landlord to actually go to court on that issue and actually be successful would probably cost about $15,000 to $20,000 in attorney fees. And that's just not sustainable for a small mom and pop landlord who might only get $15,000 to $20,000 in rent in an entire year to begin with.
Yeah. With input from Ryan and another attorney at his firm, I created this little informational flow chart to help people understand the 10-day comply or vacate process. So it starts with, in the case of something like harassment, an aggressor harasses another resident in the building or perhaps the owner. The property owner issues a 10-day notice to comply with the lease rules or vacate. Okay, the aggressor may continue harassing the victim for an additional 11 days. At that point, if they continue on the 12th day, then the property owner may proceed to eviction court. But if they discontinue on the 12th day, the aggressor can stay. And as long as they don't harass the victim again for 60 days, they're fine. After 60 days, they can start harassing the victim again. And the property owner has to go through the whole thing all over again. And they can go through this cycle a total of 3 times before the property owner can finally proceed to eviction court, which can still cost $15,000 or $20,000, as Ryan noted in the interview.
To get the next story as soon as it comes out, click like and subscribe.